Ex-Judge Luttig urges Supreme Court to keep Trump off ballot, citing insurrection. A headline that rings with both controversy and anticipation. This is a tale of politics, power, and the pursuit of justice. In the thick of this story, we find J. Michael Luttig, a former conservative federal appellate judge. He's taken a bold step, filing a friend of the court brief with the nation's highest court. His call to action? To keep former President Donald Trump from appearing on the ballot. Luttig's argument is a weighty one. He equates Trump's post-2020 election actions to South Carolina's secession from the Union, an event that ignited the Civil War. In his eyes, the former president's efforts to retain power were an armed insurrection against the Constitution. As such, he believes Trump has disqualified himself from holding office under Section 3 of the Constitution. This extraordinary claim has sparked the interest of the U.S. Supreme Court. They've agreed to review the decision from the Colorado Supreme Court, which had previously removed Trump from the state's ballot. The stage is set for February 8th, when oral arguments in this case will be heard. But Luttig isn't alone in his quest. Other prominent lawyers, including George Conway, have also submitted the brief. They urge the Supreme Court to look at the issue through a textualist lens, arguing that the 14th Amendment's insurrectionist ban enforcement falls within the court's realm, not just Congress. They've also taken issue with Trump's argument that the ban can only be enforced after a candidate is elected. They argue that this stance would rob voters of making an informed decision, creating potential chaos in the country. So, in summary, the key points of this news are: a former judge, J. Michael Luttig, has filed a brief urging the Supreme Court to keep Donald Trump off the ballot, citing an armed insurrection against the Constitution. The Supreme Court has agreed to review a previous decision that removed Trump from the Colorado ballot, with oral arguments scheduled for February 8th. Prominent lawyers, including George Conway, support Luttig's brief, arguing that enforcing the 14th Amendment's insurrectionist ban falls within the court's purview. They criticize Trump's argument that the ban can only be enforced post-election, stating that it would deprive voters of making an informed decision and risk chaos. This story is a reminder of the complex interplay between politics and the law, and the ongoing debates about the boundaries of power and accountability. This is a case to watch, as it could set a precedent for future political and legal battles. The outcome could very well reshape the American political landscape.